Good morning to you all. Yes. Mr. Siminya.
Good morning again, Chair, and to the other commissioners. The Commission will realize that we have Ms. Suka again, and this follows a supplementary affidavit filed by her. She will be led by Mr. Vani.
Yes. Thank you. Mr. Vani, you confirm that?
Yes, Chairperson.
Thank you.
Excuse me, I do confirm that.
Thank you. Ms. Suka, welcome again to the Commission. Are you going to give your evidence under oath or affirmation?
Good morning, Commissioners. I'll give it under oath.
Thank you. Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you, Ms. Suka. Mr. Vani.
Thank you, Chairperson. Ms. Suka, thank you for coming back to the Commission. As indicated by Mr. Semenya, you have testified previously. And can I just get you to confirm that you previously submitted a statement that's dated the 4th of November 2025, and that you testified orally before this Commission earlier this year on the 17th of February 2026?
I confirm that.
Commissioners, Ms. Suka's first statement is in Collateral Group Bundle 5. And reference has also been made to a supplementary affidavit dated the 10th of July 2026. Can I ask if you have that statement before you, and whether this is your statement and your signature, which is appended on the last page?
I confirm that this is my statement, and that's my signature on the document.
And just
sorry, Mr. Soni, switch off your other microphone, please. Sorry, Mr. Vani.
No problem, Commissioner, thank you. Ms. Suka, just before we commence, can you just remind the Commissioners of who you are and your current designation, and perhaps your connection to the Truth and Reconciliation Commission?
Thank you. Commissioners, I was a former member of the South African Truth and Reconciliation Commission. I served from 1996 to 2001, when the Commission closed its doors. I was also responsible for making sure that the final report was handed over to President Mbeki in March 2003, and served in a number of other commissions around the world. I currently chair the Commission on Human Rights for South Sudan for the Human Rights Council in Geneva.
Thank you, Ms. Suka. Now, we intend to be quite brief with you today, and in fact, all I'm going to ask you to do is to read your statement into the record, and then we will close the evidence in chief, and other parties and the evidence leaders may have questions for you. Chairperson, before I ask Ms. Suka to read her statement into the record, I want to bring the Commission's attention to paragraph 30 of her statement. In that statement, Ms. Suka makes reference to a meeting held with the Reverend Frank Chikani in 2012. And it's disclosed that I accompanied Ms. Suka to that meeting. So I disclosed that up front, but indicate that for purposes of the evidence before the Commission, we rely exclusively and only on Ms. Suka's version.
Yes. Thank you.
Thank you, Chairperson.
Would we be able then to cross-examine Mr. Chair?
Ms. Suka, you may commence reading your statement into the record.
Thank you, Commissioners. I, the undersigned Yasmin Louise Suka, do hereby make oath and state I'm an adult female and I reside in Johannesburg. I'm a member of the board of the Foundation for Human Rights, which is situated at Metal Box Building, the 7th floor, 25 Arl Street, corner Stanley Avenue, Auckland Park, Johannesburg. I'm a former commissioner of the South African Truth and Reconciliation Commission and the Sierra Leone Truth Commission. Since 2016, I've served as the chairperson of the United Nations Commission on Human Rights in South Sudan. Save where it appears from the context, the facts contained in this affidavit are within my own personal knowledge and are, to the best of my knowledge and belief, both true and correct.
Sorry, it would help if you refer to paragraphs, but you don't have to go back.
Okay,
Thank
great.
you.
Thank you, Commissioner. Plea and during 2012, I approached Reverend Frank Chikani with a request to meet him to discuss the applications for political pardons in respect of those who'd been convicted for his attempted murder. And on the 17th of August, in terms of the plea and sentence agreement concluded, on the 17th of August 2007, former Police Minister Adrian Flock, former Commissioner of Police General Johan van der Merwe, Major General Christoffel Smith, Colonel Gert Otto, and Colonel Johannes Mani van Staden entered into a plea and sentence agreement for their roles in the 1989 poisoning of Reverend Frank Chikani. They pleaded guilty in exchange for suspended sentences in terms of Section 105A of the Criminal Procedure Act. Flock and van der Merwe were sentenced to 10 years in prison, suspended for 5 years, while the other 3 received 5-year prison sentences, suspended for 5 years. A copy of the plea and the sentence agreement is already before this commission in the Kalata Group Bundle 1. So going to the question of the special...
Ms. Suka, if I can just interrupt you for a moment. There has been a request from my colleagues that before each paragraph, you just mention the paragraph number.
Commissioner Fomo, Chair, not your colleagues. We were just reminding you.
Yes, it was Commissioner Kumo who made the request. So just before each paragraph, if you can mention the number that you're in.
Okay. I'm going to paragraph 8 of my affidavit, and that deals with a special dispensation on political pardons. Now, at a joint sitting of Parliament on the 21st of November 2007, President Thabo Mbeki announced a special process for the handling of pardon requests made by people convicted for offences they claim were politically motivated and who were not denied amnesty by the TRC. That's in inverted commas. According to President Mbeki, the aim was to assist the nation in resolving the unfinished business of the TRC. The use of the pardon power to accommodate perpetrators who had spurned the TRC amnesty process was in line with the recommendations of the Amnesty Task Team that had been made in 2004. President Mbeki asked each political party represented in Parliament to appoint a representative to serve on a reference group which was charged with considering pardon requests and submitting recommendations to him. Applications for the political pardons opened in January 2008, and the chairperson of that reference group was Dr. Tertius Dalport. According to paragraph 11, more than 2,000 persons applied for political pardons, and the reference group recommended to the President an initial list of some 150 persons to pardon. Amongst those who were recommended for pardons were those convicted for the attempted murder of Reverend Chikani. The reference group rejected requests from victims, families, and civil society to make inputs into the political pardons. And as a result of that, in March 2009, civil society brought an urgent application in the Pretoria High Court to interdict the president from issuing any pardons until they were able to participate in the process. On the 28th of April 2009, Judge Sariti granted an interim interdict restraining the president from proceeding with a special dispensation for political pardons. Paragraph 13. On the 2nd of June 2009, President Jacob Zuma and Ryan Albert, one of the RVOBA members convicted for carrying out a campaign of violent terror against black people in Kuruman, approached the Constitutional Court to overturn the interim interdict. In February 2010, the Constitutional Court ruled that no political pardon could be issued without first affording the victims a hearing. Paragraph 14. Attempts were thereafter made by the Ministry of Justice to resurrect the special dispensation on political pardons by allowing victims and interested parties to make representations, and the process was reopened to permit interested persons and parties to participate and make submissions. Going to the objections to the pardon applications set out in paragraph 15, several civil society groups submitted representations to the reference group opposing the grant of pardons to those behind the poisoning of Reverend Chikani. Their central objection was that the applicants had not disclosed key facts around the program to eliminate anti-apartheid activists. Going to the question of the refusal to disclose the truth, set out in paragraph 16 and 17, the applications for pardon by Flock van der Merwe and the others were very carefully crafted and appeared to deliberately avoid implicating any living person. For example, General van der Merwe in his application referred to a meeting held in 1987 at the headquarters of the South African Defence Force to discuss actions to be taken against various targets. And present at the meeting were representatives of the SADF, the Security Branch, National Intelligence, Military Intelligence, and the SADF Special Forces. Van der Merwe only disclosed the names of the late General Kat Liebenberg, then Chief of the Army, and the late Brigadier Broodryk of the Security Branch, and no names of living persons were revealed. In paragraph 17, at the meeting it was disclosed that the instruction to murder anti-apartheid activists, including Reverend Chikani, came from a higher authority, in inverted commas. Van der Merwe and Flock did not disclose who this higher authority was. Van der Merwe indicated that the meeting was told that this higher authority instructed that drastic steps, in inverted commas, using the full capacity of the state, inverted commas, had to be taken against certain political activists. In so-called extreme cases, again in inverted commas, they could be eliminated, in inverted commas. The applicants did not disclose what constituted extreme cases, although it is evident that it included civilians, non-combatants, and even men of the cloth, such as Reverend Chikani. According to Van der Merwe, the hit list discussed at that meeting was compiled by military intelligence, and that internal targets were the responsibility of the security branch, while external targets were to be handled by the Defence Force. Paragraph 20, Van der Merwe only disclosed two names on the list, the one being Chikani and the other the late Joe Slovo, who at the time was based outside South Africa. Since the preferred method of elimination was to give the impression of a natural death, as in the case of Reverend Chikani, the absence of disclosure made it difficult, if not impossible, for investigators and researchers to identify other individuals who may have been targeted through similar methods. It is highly likely that several of the other targets were eliminated in a manner dressed up to look like the natural or accidental death. Paragraph 22, according to Van der Merwe, following the meeting, he reported to Flock and gave him a copy of the hit list. Flock was also in a position to disclose names on the list, but declined to do so. Paragraph 23, Flock and Van der Merwe set up a unit, and in inverted commas, for the execution of the directive, close inverted commas, and recruited various officers to carry out the unlawful operations described in the plea agreement, including Otto, Smith, and van Staden. These three were also in possession of names on the list, but refused to disclose any names besides Chikani. None of the pardon applicants disclosed the names of the unit, its members, and the modus operandi it employed. Paragraph 25, it is known that on the 14th of July 1986, Adrian Flock briefed the State Security Council. He briefed the meeting on steps to be taken against, in inverted commas, politically sensitive persons, close inverted commas. At the State Security Council meeting of the 8th of September of 1986, under Agenda Item 2, Report on the National Emergency, Item G was titled, The List of Politically Sensitive Persons. It was recorded that the list of politically sensitive persons had to be shortened and methods other than detentions must be considered. Flock was tasked at this meeting of the 22nd of September 1986 under Agenda Item 3D, Report on the National Emergency. It was recorded at Item D that the list was accepted after discussion, and that's in inverted commas. Paragraph 26, Flock never disclosed who was on the list of politically sensitive persons and what the steps taken against them, other than detention, and whether this list was the same list discussed with the SADF a year later. This truth is part and parcel of South Africans' history. It would have been immensely important for the families and communities of those individuals who did perish from such actions to know exactly what happened to their loved ones. However, Flock, Van der Merwe, and the others specifically chose to conceal the truth from South Africans. In paragraph 28, since they refused to disclose the truth, the South African History Archives, the Human Rights Media Center, and the International Center for Transitional Justice filed a submission opposing their applications for pardon, stating that, and I quote, a granting of pardon in these cases will seriously undermine and retard national reconciliation, since the applicants have specifically chosen to deceive South Africans and deny the nation important truths of South Africans' past, close quotes. Approach to Reverend Chikani, starting at paragraph 29. Those opposing the pardons believed it would be particularly powerful if Reverend Chikani called upon those who tried to kill him to come clean and speak the truth. It was decided to approach him to make this call and ask him to oppose the applications until they provided answers. Paragraph 30, I was asked to make up this approach. I set up this meeting during 2012 and arranged for the meeting to take place at the Protea Hotel in Melrose Arch in Johannesburg. I was accompanied by counsel for the families, Advocate Howard Varney. Paragraph 31. At this meeting, I explained the critically important truth that was being specifically withheld by Flock, Van der Merwe, and the others, as set out above. I also pointed out that there are probably many families whose loved ones were murdered in similar operations, but who will never know the truth unless the applicants disclose in full. I explained that in my view, if he took a public stand and called for the truth, Flock and the others might be moved to disclose the full truth, in which case the opposition to the pardons could be withdrawn, and this would have been a powerful and symbolic act of reconciliation and healing. Paragraph 33, I urged him to consider opposing the pardon's applications unless full disclosure was made, and I said that this would be in the best interests of the victims, the families, and in the greater interests of South Africa. However, Reverend Chikani refused to take a stand in the matter. He also refused to oppose the pardon applications arising from this case, and he would not be moved. Paragraph 34, when I asked him why he was unwilling to assist, he said that he had been poorly treated since he left government, but he didn't explain why such treatment prevented him from taking a stand. Paragraph 35, I was bitterly disappointed with his refusal to stand with the families and victims of apartheid crimes who were waiting for answers. Paragraph 36, Reverend Chikani, of course, has asserted before this commission that his principal concern has been the pursuit of truth. I considered it appropriate to place before the commission my account of our 2012 meeting, as it's relevant to his claim that Flock and van der Merwe had come out of the woodwork, taken off their masks, and moved from their strategic lies. In fact, as late as 2012, they were still engaged in a cover-up of the truth. Paragraph 37, and his refusal to take a stand in pursuit of important truth for South Africans, I think, undermined his claim that his overarching concern was truth-seeking. Thank you.
Thank you, Ms. Suka. Chairperson, that brings the evidence-in-chief to a conclusion.
Thank you. Ms. Moroka?
Chair, if I may, again to say good morning to an old friend that we used to have chips in a corner at the university. Advocate Khomo, I'll wait for her to say good morning to you.
Good morning, ma'am.
No, it's for her to say good morning.
Oh,
And you protected me the last time.
Good morning.
Chair, if we may, we reserve the right to cross-examine Ms. Suka.
You reserve the right to cross-examine.
We have every
When do you
intention-
intend to apply for such cross-examination?
I'm informed, Chair, that by my junior that we would need the documents that have been referred to, the applications for pardon, for us to be able to have a full view and then prepare our
Yes,
cross-examination.
but are you able to estimate when the application to cross-examine will be made before me?
Chair, the cross-examination depends on all the documents because we must refer you to the documents that we need to put through.
Yeah.
Unless Mr. Van is able to tell us when we can get those documents.
Chairperson, yes, happily I'm able to advise that the documents are ready with the Commission in the bundle that was circulated, I believe, on Monday. We can
Yes.
assist my learned friend to get access to those documents.
Yes. Don't you have the bundle, Ms. Moroka, that we have in our papers?
We have looked, my juniors
Yeah.
might just, if we do have the bundles and if we do have the documents that have been, reference has been made to, can we say Tuesday, Chair?
Okay, that's fine. Ms. Ntloko?
Good morning, Chair. We don't have any clarification questions, but we also hold instruction to reserve the right to cross-examine, and if we are, we will give that application by Tuesday as well.
Thank you. Anyone online?
Thank you, Chair. Mr. Mshizana, we have no questions for the witness.
Thank you.
Thank you, Chair. Thank you, Chair. Ms. Ntambeleni, we have no questions for this witness.
Thank you, Ms. Ntabeleni.
Thank you, Chair. Ms. Ricoto, we have no questions for this witness.
Thank you.
just this one, I just wanted to find out the Minister, yes, paragraph 14, attempts were made thereafter by the Ministry of Justice to resurrect the special dispensation pardons by allowing victims and interested parties to make representations. Who was the minister then? Can you recall, Ms. Suka?
I stand to be corrected, but I think it might have been between Minister Surti and Minister Mapandla. I'm sorry, but I was going through a list of them and I'm a little,
Okay,
I'll have to check that.
Okay, we'll find that out, and
Yes.
Mr. Vani will also help.
Yes.
Even if it is not today. Thank you
Yes,
very much.
yes, yes.
Thank you.
Ms. Suka, I think you've missed out, unless I didn't hear you, paragraph 4 of your affidavit. Perhaps you want to read that into the record?
Yes, perhaps I misunderstood that I was not supposed to read it, so I kind of went to paragraph 5, but let me read it here. I depose to this affidavit to assist the Judicial Commission of Inquiry in to stop TRC investigations and/or prosecutions, known as the Commission, to address paragraphs 1 to 1.3.2 of the terms of reference of the Commission.
Thank you.
Ms. Suka, we thank you for having come again to this commission to give evidence. As you have heard, there is an intention to launch an application for your cross-examination. So you will be expected to return to this commission for such cross-examination. But for now, you are excused as a witness. Thank you, ma'am, for attending.
Thank you, Commissioners.
Thank you.
Chairperson, may I place on record, you will recall that it is the evidence leaders who called Reverend Chikane as a witness, and on the basis of what Ms. Suka has said in her affidavit, we've consulted with Reverend Chikane. We do have his response. I'm just placing that on record, but it appropriately should be left to the end when the others have cross-examined.
Yes.
I'm placing on record that
Yes.
you have Reverend Chikane's response to Ms. Suka's allegations.
That is noted. Yeah. We'll take a short adjournment before we proceed with the evidence of the next witness.
As you please, Chairperson, be grateful.
Will 5 minutes be appropriate, or do we need more than that?
Perhaps 10 minutes, Chairperson.
10. We'll take a 10-minute adjournment.
Yes.
Mr. Semenya?
Chairperson, our next witness is Mr. Pigo.
Chairperson, I will be leading the evidence of Mr. Pigo.
Yes. Mr. Pigo, are you going to give your evidence under oath or affirmation?
Affirmation, Chair.
Yes. Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Chairperson. Thank you, Commissioners. Mr. Pigo, you have a statement in front of you. It is marked pages 2438 to 2472, or 73, sorry. Is that correct?
Correct.
Yes. And on the last page is a signature. Is that your signature?
It is.
And then in addition, you have an affidavit in front of you. Do you see it? Do you have it?
That's
Mr.
correct.
Pigo? And in that affidavit, you confirm the correctness of what is stated in your statement.
That's correct.
All right. And do you confirm that?
I do confirm that.
formally now. Thank you. Now, Ms. Pigo, firstly, let me thank you so much for coming to the Commission to give your insight into matters. In your statement, if I could just give a roadmap of it, you indicate your experience your experience in regard to the TRC processes and your subsequent involvement and interest in post-TRC matters.
Yes, that's correct.
One of the reasons I'm going to ask you to give as much detail on it as possible is a lot of the evidence that you give is commentary or opinion evidence. And one of the purposes of some of the paragraphs of your affidavit is to indicate to the commissioners that you are a person whose views can be taken seriously because of your involvement in these matters. So I'm going to ask you to deal with those in some detail, if you don't mind. But can I ask you, first of all, to look at paragraph 3 of your affidavit? And Ms. Pigo, before you do that, feel free to refer to your affidavit, to read from your affidavit, to go to different parts of the affidavit to the extent that you want. But if you could keep this in mind, it would really be appreciated. The commissioners would have to write a report, and if your evidence could be in some sequence that allows them to formulate your evidence in a structured form, it would be helpful.
Okay.
Right, let's just look at your connection, as you express in paragraph 3 of your letter, between the TRC process and the post-TRC developments. If you could just indicate to the Commission why you think what happened during the TRC process is relevant to the terms of reference of this Commission.
Thank you. I mean, there is, towards the end of the affidavit, a explanation or a discussion about political environment and context, and that may be something you want to leave until then.
Yes.
But that really is the setting for the connectivity between TRC and post-TRC related issues, because that also has antecedents in the way in which issues of accountability around violations in the apartheid era were dealt with either during the pre-94 period or indeed into the post-94 period with the truth commissions and so forth. So my own particular interest, having been involved in the Commission's investigation unit, was largely in relation to the work of civil society organisations that I was either a member of or tangentially involved in, and a broader set of discussions about how post-TRC related issues, and not exclusively issues of prosecution and investigation, but that included but other issues around record keeping, archive, reconciliation, reparation issues, etc., through the lens of those organisations. So there is a consistent pattern of interaction with civil society organisations in the 25 years that have followed from the early 2000s.
Can I ask, and tell me if I'm summarizing the essence of what you've just said, is that in order to understand what has happened since the TRC process, in particular the issues that this Commission is dealing with, it would be helpful to keep in mind what happened during the TRC process.
Yes, I think it's important to understand the mechanics of the Commission, the strategies that were unfolding in the Commission. And I give this from my vantage point inside a regional investigation unit. So this does not necessarily mean I have an overarching umbrella view of everything, but I was actively engaged during the Commission process around those issues, and then obviously subsequently. So was able to see how those processes in the Commission may have impacted in relation to the issues that were pushed forward post-TRC, and that includes prosecution-related concerns.
Yes. Now, in regard to your involvement with TRC processes, I'll deal with that in a moment. Can I ask you, and you deal with this in paragraph 4, what are you busy with at the moment in terms of your contribution to society?
Thanks for that. I since April, have been the director of a small non-governmental organisation called Intel Watch, which monitors the role of intelligence services on the continent, the policy environment, the regulatory frameworks in which intelligence organisations are operating, looking at new technologies around surveillance, but with a view to looking at how those things are misused and to how civil society can tool itself up to engage in a more constructive way with those agencies to improve public oversight of intelligence communities. It's a space that very few people are working in, and it is, as you can imagine, sometimes a controversial and sensitive space.
In essence, as I understand your paragraph 4, you want to ensure that those involved in those activities are held accountable for how they operate.
Well, it is about strengthening. It's a governance issue in its essence, and it certainly relates to a wider interest, which I think the Truth Commission was interested in terms of institutional responsibilities around violation, and what are the checks and balances that are in play to ensure that legitimate intelligence work, of which there is much to be said, can continue, but it is dealt with, given the concerns about the role of intelligence services through the experiences that we had in the South African context.
To ensure that such abuses don't take place, rather than look at it 10 years later after the abuses have had adverse consequences for society.
Well, that's the wider objective. I think the initial objective is simply to shine a light on these issues and try and promote constructive debate and conversations and engagement on those issues, because so few people are engaged on that front.
Then in paragraph 5, you set out the basis on which you've come to know the TRC processes and your interest thereafter. If you could summarize or read what he said in paragraphs 5 to 9 of your affidavit.
Sure, let me summarize it so I don't delay you too further. I joined the regional investigation unit based in Johannesburg. In around March 1996, I was approached to join the investigation unit while it was being established, and I stayed with the investigation unit, working directly for the Commission and then subsequently on a contract basis for about a period of 2.5 years.
Mr. Pigo, before you go on, I think you must address the commissioners.
Apologies.
Because it is
Okay. Apologies, Commissioner. I was involved in the investigation unit in terms of the Johannesburg work. I subsequently had to leave the Commission, which had nothing to do with the Commission itself, but came back in a contract basis and worked on a few cases with the Commission, and also was involved in writing some components or drafts for contribution to the TRC's final report, the actual interim report, handed over to the President in November 1988. And I also, 98, and I also was involved in a pro bono way with a number of amnesty investigations working with families, challenging and looking at the versions presented by certain amnesty applicants during the period from around 98 through to 2000, around that period, several of those cases. Subsequently got involved in a fair amount of writing and commentary around the TRC, have contributed to newspaper articles, chapters in books, and so forth, and also giving public talks about the TRC. And that also included working at the International Centre for Transitional Justice for a while and providing some training modules for them when they had an office established in Cape Town, looking at the Truth Commission. And I continue to be called on to reflect on the Truth Commission by various NGOs and organizations, one called in Transitions Initiative, which, for instance, this week has asked me to go and talk to a Yemeni delegation later this month about their attempts to look at how to deal with the past. So that work continues in terms of reflection. And I have continued to follow, as I said earlier, a number of processes related to the TRC over the last 20-odd years, and also more broadly issues around the accountability agenda itself, wider than the TRC, because I strongly believe the TRC was only the beginning of a process of looking into the past, a part of a much longer process of truth recovery. Thank you.
All right. In paragraph 6, you mention the different commissions that looked into atrocities of the past. The Harms Commission, the Goldstone Commission, and the Steyn Commission. Is that an area of interest as well?
Well, yes, it has been. Before I joined the Truth Commission, I was an employee of an organisation called the Independent Board of Inquiry into Informal Repression, which had been set up in the late 1980s by a number of civil society activists, including the Reverend Frank Chikane, Alan Bosak, Archbishop Tutu was on the board, Brian Curran, Sheena Duncan, people like that. And the objective of that organisation was to investigate the state's role in covert operations and what we termed informal repression, in assassinations, torture, that kind of work. The IBI, as it was known, the Independent Board of Inquiry, was involved in supporting the work of the law firm Cheadle Thompson Haysom that was representing victims in the Harms Commission. So there was a direct interest there, and in its predecessor, the McNally Commission, looking into issues of hit squads. So we had a particular interest in that during the early 90s here. Before 94, obviously the Goldstone Commission was of critical interest as one of very few remedial mechanisms that were available to look into allegations of covert violence and so forth. So we were keenly looking at those issues, how that then translated into investigations by the Attorney General's Office, also fed by the outcome of the Steyn report, Major General Pierre Steyn's report into covert operations between December 1992 and around February, March 1993. So looking at all of these different processes that also led into the Truth Commission, and then subsequently into the post-TRC. So I like to look, I like to frame this in a much wider set of processes that have been in play. Thank you.
And just again to get back to the point of continuity, this commission should at least consider those matters when it looks at the failures of investigations and prosecutions post the TRC process.
That is correct. I put that under a broader rubric of the politics of investigation and prosecution with a small p, in terms of the factors that were influencing resource allocation, which elements came to the table, who was resisting, and it's about acts of omission as well as commission during those periods. And I'm trying to understand the dynamics that were at play within and between institutions also that were operating in these spaces.
Mr. Pigger, you used the phrase, the politics of prosecution, and I know you use it a few times. Would you explain what that means and how it plays out?
Thank you. The Commissioners, it's a general term in which one can mine down in different ways, but it's really to try and understand the milieu in which commissions trying to look into or tasked with looking into particular sets of allegations around past violations have been able to navigate their mandates. Its relationship with the state and state resourcing, and its relationship with individuals and institutions. Now, we fly blind to a large extent on many of those relationships, but I think it's important to understand what is brought in front of commissions and what can be interrogated relates to individual and institutional interests and cultures and priorities and so forth. So I think it is important for us to examine the wider context in which these issues are taking place. If I can give you perhaps an example, we know, and we perhaps will get into this in more detail, we know that there was no solid decision by April 1994 on the issues of amnesty and what an amnesty would actually look like. And there were different perspectives and interests in play around what that might be. Big expectations from within large elements of the security services, the apartheid security services, that they would receive some kind of general amnesty, something that might resonate with the indemnification processes that were put in play in 1990 and 1991. And in fact, there are assertions that, that those general amnesties were going to be in play. You see this in a book by Philip Frankel called Soldiers in a Storm, about the negotiations that were taking place between the SADF and Nkonto Sizwe, where there was an understanding a general amnesty would be brought to the table, but that was not delivered. So there are these dynamics in play in the background around the accountability agenda and disclosures, which I think have an enormous import for the processes that subsequently play out in various commissions of inquiry.
In paragraph 7, Spigo, you deal with the mechanisms that you call the backdoor amnesty process in respect of the prosecution policy amendments, and then the new pardons process that we heard about this morning when Ms. Suka gave evidence. And you say these are matters that you reflect on as well.
Yes, I wasn't directly involved in the mechanics of those processes, but was certainly part of civil society organizations that were party to the discussions that were in support of challenging both the new prosecutions policy and then subsequently the pardons process. I heard this morning from former Commissioner Suka that the South African History Archive, for example, was involved I wasn't the director of the South African History Archive at that point. That happened a couple of years later. I was involved with the Kulamani Support Group for a number of years, and in those circles. So yes, very much aware of those live issues playing out during the time that I think it was very much prosecution and reparations related issues that were getting a lot of attention from the civil society groups at that time. So I was familiar with those.
In the last sentence of paragraph 7 of your statement, Mr. Pigo, you point out that these were processes that were taking place, and then you point out why it is likely that there was no enthusiasm for prosecutions.
Yes, in that final sentence, I said there was a clear impression from what was happening that there was limited interest in pursuing a prosecution strategy. I mean, this was simply playing out from the lack of progress in the cases, the lack of allocation of resources. From my vantage point in terms of civil society engagement, I was looking again at a much wider angle lens on those issues. And that reluctance to engage with these issues was playing out on multiple fronts. I mean, I'm cautious that this is not about comparing those issues, but it was indicative of a lack of interest from the state, at least, to resource processes which had come out of TRC recommendations. And prosecution, we knew from the Mohammed Constitutional Court judgment, was an investigation, was something that there was a very specific legal mandate and responsibility on the state to pursue. So, of course, there was a particular interest in that interest in terms of legal responsibilities, which I don't think played out in the other areas of recommendations. I mean, we could make some arguments about record keeping and those kinds of things, but the prosecution issue, there was a particular responsibility on the state. So this is why there was a particular interest, and I think that reflected in the commentary the concern that nothing was being pushed forward. Initially, after 1998, the rationale was always, well, we can't pursue these matters because the Truth Commission hasn't finished. This perplexed me at the time because there were a number of cases which weren't necessarily in front of the Truth Commission, but related to TRC matters in that they were dealing with the conflicts of the past that could have been pursued during that time. And those cases, actually, some of those were being investigated. But there was a wider concern about what resources were being allocated into these processes, even by the late 2000s, early 2000s, sorry, the early 2000s.
Would that be, would one of those be the Dolivera unit's investigations?
Well, the Dolivera unit was one of the primary teams from the prosecution authorities that were directly responsible for in-depth investigations, or prosecution, should I say, into those cases, and unfolded, as we saw during the TRC with the de Kock case, subsequently with the Basson case and so forth. So it wasn't as if they were sitting on their hands, per se, but it was, I think, a concern that there was limited resources that were tied up in these complex cases, and it was quite obvious there needed to be an expansion of resources and capacity to be able to take on other responsibilities.
Just dealing with that issue, one would imagine after the TRC report that there would be a huge inflow of resources to ensure successful prosecutions.
Well, I guess in theory, yes, one would imagine that. I mean, within a broader context of resource mobilization and competition over prioritization. But yes, it was evident that more resources should be allocated in this direction. And whilst you can make certain arguments around limited resources, this was clearly decisions that were influenced by the priorities that were being taken by individuals inside the prosecution authority, it seemed to me, and those that were resourcing the prosecution, making decisions about the resourcing of the prosecution teams, and of course the police, because we saw this backwards and forwards finger pointing between the police not providing resources, saying that they couldn't, etc., and the NPA pointing fingers at the police pointing fingers at the NPA, and so forth. So there was no one, it seemed to me, that was banging heads together to ensure that the resources were properly applied.
In your view, was that accidental or probably by design?
I would say by design, in some respects. I mean, of course, there's always environmental considerations to look into in terms of what was achieved and what wasn't achieved. But it seemed evident to me, and it's something I state quite firmly at the end of this affidavit, is that there wasn't a political will to drive this particular agenda. And that was, in my opinion, by design.
And that the agenda you're talking about is investigating and prosecuting cases related to the atrocities of the past.
That is correct. And that is in relation to across the conflicts of the past.
And when you say across, are you talking about both from liberation movements and from the security structure?
That's correct.
Then, Mr. Figo, in paragraph 9, in paragraph 8, you've referred to already your interest in your involvement in the South African History Archive. And in paragraph 9, you set out the roadmap of the next few pages of your affidavit. And you say you will deal with the mandate of the TRC, the structures that were created, for example, the investigating unit, the Human Rights Violation Committee, and the Amnesty Committee. We start off with the section that's headed the mandate of the TRC. That's at starts at paragraph 10.
Well, I'm sure you're familiar with the mandate, so I don't want to go into too much detail in relation to that. Perhaps I can just some highlights of concerns that came from that. I think the original time frame of the Commission, in fact the overall time frame of the Commission was unrealistic from the get-go. It was extended several times, but my experience of the Commission was that it was constantly having to run against the clock. That obviously is something which many commissions will be familiar with. But given the wide mandate that it had to deliver, this was an enormous undertaking for a commission that had to get up and start running as quickly as possible following the initial appointment of commissioners in December 1995. So, it had to hit the road running. I think you'll see that in this affidavit I talk about kind of major design faults in the way that the Commission was established, the nature of the relationship between the Human Rights Violation Committee and the Amnesty Committee not working closely together, the absence of a set-up period, which was not in the legislation. And it's important to remember that the Commission itself was constrained by the legislation that it had to operate with. So when people blame the Commission for things, they should actually, and the design faults, for example, some of those can be looked at internally, but certain major design fault concerns came from the legislation itself. Every commission, I think, or many commissions post the South African Truth Commission have had a period to establish. They've had a 3, 4, 5, 6 month setup period in order to get their ducks in a row, to do their recruitment, to get their policies and procedures, their infrastructure organized and so forth. I use the expression that the South African Commission was trying to fly the plane while it was still building it. And that was a huge design fault in terms of the limitations that it put on the Commission. And it played out in terms of recruitment and strategies that teams were not fully complemented, often throughout the entire life of the Commission itself. So lots and lots of problems at that level.
Can I just
Yes.
interrupt, Mr. Speaker? You deal with that in paragraph 11 of your affidavit, that general assessment. And what you've set out is a summary of what's set out in paragraph 11.
Yes, thank you for that. I think, what I've also said in terms of the sections leading up from paragraph 13 to 16 is the success of what the Commission did around its mandate in terms of public hearing processes, its disclosures that were made and admissions that were made, which had been for years denied. So we had on the record for the first time acknowledgements of involvement of state security forces in violence. We had admissions coming from other key actors in the conflicts of the past. And so issues, as I said, that had previously been massaged and manipulated, denied, avoided, and so forth, were put on public record for everyone to see in a very public process. You've heard this before, I'm sure, but the South African Commission's, the nature of its public engagement was extremely important in terms of the wider influences that had on how commissions elsewhere around the world dealt with past conflict violations. And of course, the Truth Commission was a very important exercise in identifying and gathering as much documentation as possible relating to the past, either excuse me, through its primary data collection processes of statement taking, but also through the gathering and collation of a wide range of secondary sources of data.
At paragraph 14, Mr. Speaker, you make the point that for the first time, the marginalized could air their real grievances in public without fear of retribution and so on. Is that significant on account of the oppressive past from which we came, and in which restrictions on complaints of what was happening in society were imposed?
The public nature of the Truth Commission process was deliberately designed to provide a platform for victims and survivors, to give emphasis to their versions of events. And so, as I said earlier, this was unprecedented in transitional justice, Truth Commission related processes. But it was extremely symbolic, of course, in the way that played out in the public arena, and was a critical part of I think, providing an official public space that had the protection of the Commission and society at large, I think, for people to express what had happened to them. So this had enormous symbolic value at the time. And obviously is something that has been pursued by other processes elsewhere. The value of that has been recognised.
Is that model of public participation in the public space being replicated? Has it been replicated in other truth?
I think generally within scholarship around transitional justice, there is a recognition that the South African Commission gave enormous impetus to that kind of focus. I mean, there was a lot more we could have done in relation to those issues, but this certainly was a catalyst for a more systematic approach to those issues elsewhere.
Yes. Then from paragraph 17 to 19, you deal with one of the entities created by the TRC Act, namely the investigating unit. Will you summarize what is said in those paragraphs?
Yes, that just gives a breakdown of the investigation units and how they were established. At least, you know, there was a formula to have 4 regional offices. Each regional office would be staffed, and then there was a national. Each office would be staffed with an investigation team covering a geographical area. The Johannesburg unit covering the former provinces of the Transvaal, the Durban office covering KwaZulu-Natal. East London office covering the Eastern Cape, and then Cape Town office covering Western Cape, Northern Cape. I can't remember off the top of my head where the Free State was, who covered the Free State. So those, each team of 12, and then there was a national team of 12 national investigators, and then there was a deployment of international policemen that were deployed from various European countries into the commission as well. And then these investigators came from a range of different backgrounds. There were some people from an NGO background, including myself, but there was journalists, there were people with a legal background, lawyers, and there were former police officers, and including some that were seconded as well, and there were members of the former Attorney General's office that were also seconded. We in the Johannesburg unit, the head of our investigation team came from the Dolivera unit, and in fact one of the investigators, a policeman who'd been seconded there, was also part of the team. So it was a mixed bag of investigators with varying experiences. It's not clear to me a distinction between deployments and a recruitment process that advertised and interviewed people. I wasn't party to that. So yes, that was what the teams looked like.
We'll deal with your assessment of it in a short while. Then in paragraphs 20 to 22, you deal with the Human Rights Violations Committee. What was its purpose, and how did it fulfill its functions?
Well, the Human Rights Violation Committee was, initially at least, because the Amnesty Committee was, I don't know if the word dormant is correct, but it was preparing itself for its applications and to get its processes, so it wasn't getting out of the starting blocks immediately. The Human Rights Violation Committee, however, had a very clear mandate set out in the legislation in terms of what it was expected to do. And the investigation teams were attached to the Human Rights Violation Committees. It was important to establish an information flow in order to get statements in that would then be processed for the establishment of a relational database, but also for statements to be then the basis on which decisions were made and selections were made from statements for public hearing processes that took place over the course of the Human Rights Violation Committee operations. As I've said here in paragraph 21, there were certain limitations and constraints in terms of how around resources. For me, one of the major concerns about the Commission was the lack of investment in the statement-taking process. It was completely unrealistic, some of the projections that were being made. The former Executive Secretary of the Commission, Mr. Paul van Zyl, indicated to me personally in conversation that they expected the Commission to collect 100,000 statements. Completely unrealistic, thinking that 6 statement takers in each office could take 6 statements a day. I mean, just absolute, it was really unrealistic projections. And also, these were statement taking, an approach to statement taking, which did not invest in, this was the primary interface for South Africans who were coming to the Commission, and should have been an extremely important experience for many people. But I think a lot of thought hadn't gone into that investment. People were expected to come from far-flung areas into the offices, and it soon became apparent that that wasn't working and that we needed a different approach to that, and there was more outreach in terms of statement taking that was related to a framework of a schedule of public hearings that had been set up that we had to follow. So we knew we had to get statements from Polokwane because there was a public hearing coming up in Polokwane in 2 months' time. So we were often having to rush around following, and this is the investigation unit was providing some measure of support to statement takers in that regard. I've said earlier 21,000 statements were collected. Important to remember that by April 1997, and I put in parentheses only 9,000 statements had been collected. And it was at that stage that they introduced a community statement taking process in which civil society organizations allocated people with some training and background in statement taking to assist the Commission. And you had this rush of statements that were brought to the Commission between April and June that pushed it up to 21,000. And I'm afraid the quality of those statements were generally pretty poor as well. So, you know, from a social science, the social science adage of garbage in, garbage out, and I don't want to say that it was all garbage, but there were some real concerns about the limitations of the raw material that had been collected there. It was a good start, but a lot more could and should have been done in terms of investing in those processes. And in fact, it's been one of my kind of mantras over the last 25, 30 years with commissioners and with recommendations to people developing commissions: invest in your statement-taking processes. Because at the end of the day, that's the interface, as I was saying earlier, with individuals, but that's the quality of the primary, the main primary data source that you're going to collect during this process.
That's effectively the historical record that will emerge from that process.
Well, that's the part of the record which is primary data, or partly part of the primary data record. The other, of course, are other testimonies, and particularly what came out of the amnesty process, which is another issue in terms of whether that was properly assessed and analysed as well, or as effectively as it could have been.
That you deal with at paragraphs 23, at paragraph 23, the Amnesty Committee.
Yes, I mean, as we know, the amnesty process was extended again and again and again, and expanded as well, initially with only one amnesty committee. And I seem to recall that during 1997, big concerns about the limited number of people that were actually applying for amnesty. The Archbishop, I know, reached out publicly, and also in terms of engaging with institutional actors to encourage people to come forward for amnesty. And of course, there was a rush of, I mean, depending on what constituency you're talking about, there was people talk about the 7,000 plus amnesty applications that were submitted, the vast majority of which were rejected in chambers, but nevertheless, still a substantial number of cases that had to be held in public hearings, which resulted in the expansion of the Amnesty Committee into 6 separate committees that had to operate over an extended period of time and only finished its work, I think, in 2002, so 3. So this was an enormous, I think, strain on a committee that also had very limited resources at the time.
Then at paragraphs 24 to 29, you set out some general observations on the investigating unit and the Amnesty Committee and the Human Rights Violations Committee.
Yes, I mean, there are different limitations because obviously very different processes. For the Human Rights Violation Committee, I think one of the challenges was how do you determine what gets investigated? Now, we often heard in the Human Rights Violation Committee hearings a matter would be referred to the investigation unit. In my experience, there were no established referral mechanisms or modalities in place. I mean, investigators would attend hearings and would pick up on those things, and there would be interactions between commissioners and committee members with investigators. So it wasn't as if the ball was constantly being dropped, but systematized approaches, in my experience, were not in place. Also, how did you decide what matters would get investigated, given the enormity of the number of cases that were put in front of the TRC itself? You know, at the same time, we were still trying to employ, as I was saying earlier, members of the investigation unit because we didn't have a full complement. So it was somewhat chaotic in terms of the determinations of what got looked at and what didn't get looked at during that period. I've mentioned the issue of trying to operate with without having the time to prepare for that. And you know, I think the issue of functionality and systems is something that hasn't been given enough attention in terms of reviewing what the Commission was able to achieve and what it and the constraints that were on it during that time. I think I've set out there in terms of the concerns about how cases were referred, and I have talked about the investigation unit. Maybe that is a misnomer, the term investigation. Let me be clear, there was very little primary forensic investigation going on. Investigations that, for instance, looked at chains of custody and so forth. And I think this is an important observation in terms of a disjuncture between the Truth Commission and subsequent prosecution processes. Is a human rights inquiry necessarily has a much wider angle lens on issues. So investigators would be looking at a lot of contextual considerations as well. And that fed out in terms of some of the findings around corroboration, that the corroboration process that was adopted by the Commission, which I speak about in the affidavit as well. So, you know, the investigation unit was not just dealing with what you might call investigative work. We were identifying, collating existing sources of information, occasionally obviously taking additional statements and so forth, but the primary investigative work, I would argue, was limited in terms of what the Commission were doing. I think in some ways we should have had a much closer interface with the research unit because much of what we were doing overlapped with each other. Again, I think it goes down to design-related issues and understanding what the specific mandate was. But we were also involved in, as I said, assisting with statement taking, assisting in the selection of cases to go and making recommendations for cases that would be heard in public hearings, of the approximately 10% of cases that were heard in public hearing processes. Involved in Section 29 investigations and inquiries and so forth, working with various members of the Human Rights Violation Committee. And as I said, also trying to assist in making sure that I use this word cautiously, but the theatre of the TRC, because there was a theatre, there was a performative aspect to this in the public hearing processes, but to also try and make sure that that ran as smoothly as possible as well from the investigative point of view. I mean, there are other aspects here which perhaps I can just mention is the issue of corroboration. As to, at some point, the Commission needed to make decisions about who would be considered to be a victim, or a survivor, victim, and we put in place, and the investigation team was involved, I was involved in some of the discussions and suggestions around this. We put in place what was called a corroboration process. to establish if an incident had happened. So I use the example here, if your daughter was killed in an incident in Alexandra Township in 1986 and someone came to the Commission, how would the Commission determine whether that happened and whether that person could be found to be a victim? So often the person would come to the Commission and say, this is what happened, we want to know why. But the Commission, all we could do was establish, yes, the person died through various records, whether it be death certificates, media reports, other statements and so forth. But we wouldn't conduct an investigation into what happened that day and why that happened. I mean, this simply wasn't possible for the vast majority of cases that came in front of the Truth Commission. So that exercise of corroboration, which did lend to I think, a defensible methodology for making victim findings, was something that also took up a lot of time for the investigation unit, having to source relevant documentation to enable and facilitate a finding process. This extended, we were flexible in this part. I want to just extend it to one last point, is that we even use issues of what we would call, I guess, what might be called similar fact evidence of a sort, or contextual corroboration in relation to findings as well. So there was a fairly wide interpretation employed during that time.
That particular issue you deal with in paragraph 37, Mr. Speaker.
Correct. So I also just talk about the challenges of organizational, bureaucratic challenges within the investigation unit, and a sense that a lot of things were quite ad hoc, and also quite fragmented between the different investigation units, not a lot of interface. So we had a number of concerns and challenges in that regard, with priorities and strategic objectives not necessarily being clear and a lack of direction and integration. And of course, because of the size and the limited experience of investigators, much depended on what the individuals could bring to the table in terms of their resources and contacts. I think I think it's safe to say that there were very few investigative breakthroughs as a result of directly of the primary role of the investigation units. But they clearly did play an important role in a number of cases in terms of the pursuit of truth around versions that had either been presented by perpetrators or in terms of some of their own inquiries. But these were the exception, not the rule. And many of these were referred to as kind of window cases into thematic types of abuse that were taking place.
Let me ask you, who would determine which cases should be investigated and the intensity of the investigation that should accompany that investigation?
Commissioners, I think there was probably a number of factors around that. I don't think, as I said, that we had a very clear, we had a sense of certain cases should go to the national units, some cases should go in this direction, but by and large, my experience was that it played out in a much more ad hoc way. I mean, subject to correction of the experience of other people. But I think it also came down to the individuals that were involved and the kind of tenacity that they brought to the table. I have seen commentary, for example, around some investigations that there was a kind of conspiracy to go after certain people in the Truth Commission. From my experience, I had no experience of that. It was the more in-depth investigations, in my experience, were down to the tenacity of the individuals and the teams they worked with to pursue those cases. And there are some examples of that, certainly from my experience.
Yes. Now, one of the things you deal with at paragraph 41 is the issue of access to information.
Yes, I mean, It's important to remember that context, of course, of the early and mid-90s around document destruction that was taking place, and I've made one reference there to the former Minister of Safety and Security, Sidney Mufamadi, talking about files that were being destroyed. And in fact, the Commission had a dedicated inquiry into identifying apartheid-era documentation, led by Vern Harris, who had come out of the National Archives. And they did, I think, a reasonable job, but even then we know that detail on archives and documentation were withheld from that team. Certainly the organisation I subsequently was the director of, the South African History Archive, which Vern Harris was my predecessor there as the director, they established through using the Promotion of Access to Information Act in the early 2000s, we had a project dedicated to testing access to information in sensitive areas around security and intelligence and so forth. But they were able to establish by quirk of fate that the military had withheld detail on over 90% of their archives from the Truth Commission itself. And we still discover to this day archival repositories that are either sitting in state or private hands that are out there. But there's no, so the information available for the Commission, I think they gathered a lot of information, and we know that because of the volume of material that was subsequently transferred to the National Archives. And the subsequent fights that organisations like South African History Archive had to access that documentation, including documentation that was illegally truncated from the TRC's own records and hidden in the Ministry of Justice, which again, the South African History Archive was able to access most of those through legal action.
Can I ask a question? So if after the TRC process, investigations were undertaken into the cases identified by the TRC for prosecution, would the South African History Archives be the place to start?
No. Well, no. I mean, what we need to know, first of all, is what's happened with the official record of the Truth Commission. This was transferred over 20 years ago. There are no, it hasn't been properly arranged or described. There are no inventories. We use something called the transfer list, which was a list actually that the Truth Commission developed for taking that stuff from Cape Town to the National Archives in 2003, 2004. But by and large, that material has sat unprocessed. So we don't know, I mean, from the transfer list, we were able to make access to information requests to get that material. Almost without exception, those were refused. So we think that there's a lot more material, not just in the TRC archive, but within other archival spaces within the National Archives, and I would say elsewhere around the country in terms of certain record repositories, whether it's around the police, records, and if I can give you one example, during the TRC process, for instance, you might recall, Commissioner, a television program called Police File that used to occur here, and you'd see, they had a studio in a guest house in Pretoria, and in that facility, they had over 20,000 Betamax tapes, records of recordings, audio-video recordings from political demonstrations, funerals, all across up and down the country. No idea what happened to that archive, whether it disappeared or not. And what we were able to establish at SAHA was that records that had been identified, some of those records, by Vern Harris's investigation, had subsequently gone missing in the period after 1998. So, I mean, I would say that there needs to be an audit, again, of materials as to where they are. Some of them are in private archives of NGOs like SAHA and at WITS, where that archive is with historical papers. Others are sitting with private individuals as well. Across the breadth of this country, there are individuals sitting with material. And part of our big problem, which I hope the Commission might say something about, is that we have a real problem around declassification, because no decisions have been made on the declassification of those documents. And this frustrates an ongoing inquiry into the past, I think. And my sense is that it's deliberate not to address those issues, to leave those issues fudged to a certain extent.
So are you saying that when it comes to the investigation of TRC cases, those referred to the NPA, the investigation of such cases is almost impossible, or is it possible in your view?
No, I think it's possible. I mean, I think obviously it depends on what your evidentiary basis to move from, but certain investigations, it seems to me, could have been worked up. I think I mean, again, it depends on what resources were available to be able to mine those, but and how one would establish a kind of a coterie of state witnesses from within that, to have a strategy to develop. And there was a sense that, and I've said this in this affidavit, that if you look at the security police applications that came in front of the Truth Commission, the genesis of those applications came from the work of the Attorney General's office. There's no doubt in my mind that the work that they were doing and the disclosures that were made in mitigation of sentencing in October '96 by Eugene de Kock opened a door for people to be concerned. And I think there's a direct correlation there. And many of those investigations, yes, were stopped because of the amnesty process, but there was still a lot of space within that milieu to continue pursuing cases, whether they were related directly to the Commission's work or more broadly to the conflicts of the past.
Okay, thank you.
Okay.
Can I ask you, Mr. Speaker, you referred to the TRC archives. Where would that be located?
Well, the TRC archives are in the National Archives in Pretoria.
And is the material in that archive, has it been sort of investigated to see what material would be available, like you would find in, it's like going to a library and saying, I'm looking for this book.
Well,
there's no system where it can be found.
Well, collections of archival material usually go through an arrangement and description process, the development of inventories, sometimes, if you're lucky, indexes as well, for more detailed archives. There has been parts of the archive that I think have been organized, but we don't have any public record that's available to us of an organized inventory there. And our understanding, certainly when I was at SAHA, but subsequent to that, is that still has not happened, because the resources have not been allocated within the Department of Arts and Culture to do that, to process that. And that includes the limitations around digitizing the enormous repository of audiovisual archive that is there as well. And there's a real danger that we will lose that archive unless that audiovisual archive, unless they're properly protected. Yes, it remains unprocessed and largely inaccessible. The only way I know of getting into that TRC archive is if you have friends in the National Archive that might open the door to certain things, or if you use promotion of access to information law and using that transfer list.
But you won't know what you're looking for because there is no information as to what's there.
That's not entirely true. We knew, for example, one of the things that we were able to access using PIA was the Section 29 in camera transcripts, which the state refused to give to us. And we pursued legal action until we got access to all of them. So those are now in theory accessible. Through SAHA, you'll find repositories of TRC material there. And you could argue that there's more material in the William Cullen Library and at WITS, where the SAHA material is housed. There's more knowledge about what's there from there than there is from National Archives. Yeah.
And has that material been made available?
The SAHA archive is certainly publicly, it's on the website, there are lists, there are inventories and so forth. But it's not comprehensive. I think that's important to point out. It provides you with, slivers of insight into records. Some are more important than others, like the Section 29 in-camera hearings.
If one wants to cut the Gordian knot, as it were, what steps could be taken, having regard to your knowledge of what material there might be and what steps are available?
Well, what steps could be taken? I think there are a number of people, commissioners in this country, who have a relatively good idea of where certain archival repositories are, or would be able to contribute to a further inquiry into that. And so for me, that I spoke about audit earlier, that would be audit investigation into existing materials, but that should not only be a focus on the state, that should be the primary focus, but should also explore sensitively materials that exist in private collections.
And how would we know who has private collections?
Well, you know, over the years, certain researchers have been able to work and identify various things. It's a sensitive area because those individuals don't want that information in the public domain. Some of those archives have been brought into, into archives like SAHA. Some have restrictions on access and so forth. It's all complicated, I think, by the fact that a lot of those archives, state and non-state archives, include documentation which is classified. Technically, I imagine, illegal. But, you know, the classification process is a clumsy one, and I want to give you one example of this in terms of how the state messes things up. When we were after sensitive documents that had been truncated from the TRC record and housed in the Department of Justice, one of those records was the report of the Steyn Commission, or the Steyn Report it was called, which you may recall looked into certain dubious activities of members of the security forces, train violence, etc., during the early 90s. For many years it was denied that that report existed, but it was submitted to the TRC. We subsequently got an out-of-court settlement to access that record. It was sent to us in Afrikaans with all the names redacted. It was sent to us in English with no names redacted. You know, this was a clumsy administrative mistake that was made, and I think that this reflects the realities of a limited capacity within the state in terms of resource allocation to deal with these issues. It is a large undertaking to do this properly, but I think it needs to be done, and I think a declassification would make it easier to be able to access particularly private records where people are holding materials.
From paragraphs 42 to 47, you deal with your observations on the Human Rights Violations Committee.
Yes.
Would you tell the commissioners what your observations are in brief?
Well, my reflections on there are on the challenges of representativity, essentially, who came to the Commission. And in paragraphs 42, I talk about the attempt by the Commission to be as even-handed as possible in terms of making sure that different typologies of violence over different time periods in a particular geographical location were represented in the public hearing processes. And sometimes that led to a bit of a false equation, so to speak, that there was over-representation. I mean, it wasn't a perfect science by any means, but it's clear the Commission tried hard to address concerns about balance. But it was also clear that certain entities were not coming to the Commission as well in the way that we had expected. And I think that, you know, there was opposition to the Commission from a range of different social and political actors, or they weren't prepared to engage. And that included, I think, a significant part of the activist, anti-apartheid activist community as well, that didn't submit statements to the Commission didn't come forward, and let their institutions or their political representatives come forward and make those representations. But also, the mechanics of the commission itself didn't allow for large numbers of people to engage with it. And this is quite clear from the record of that has been collected. If you look temporally and spatially at the record that was collected, you will see large gaps in the record from different parts of South Africa's that history between 1960 and 1994. One example, if you look at the Vaal uprising, for instance, in the 1980s, a tiny handful of cases were collected, statements relating to that. Not very many statements from the Soweto uprising period and what happened across the country as well. So, and we see a large emphasis on statements relating to the 1990s, which was the primary period in terms of numbers of those killed and injured. So you see different groupings not engaging with the commission, and some subsequently did come to the commission. I spoke to you about that period from April to June when there was a surge of statements. A large number of those came in the KwaZulu-Natal office, in the Durban office. My understanding of that was because the Inkatha Freedom Party, which had effectively rejected engagement with this commission process and had discouraged its members from engaging with the commission, woke up to the fact that a large number of their people would not benefit from possible reparations. And this would have had some significant blowback for them. So there was this surge, I think over 5,000 statements came into the Durban office during that latter period. So, you know, there were a number of factors that contributed to who was able to come to the commission. 21,000 statements was a remarkable achievement, but, you know, and it provided a very important sample of what was there, but certainly a lot more could have come to the commission. There's no doubt about that.
And then you deal with the Amnesty Committee, your commentary on the Amnesty Committee from paragraphs 48 to 52, Mr. Bigger.
Yes, I mean, I had less dealings directly with the Amnesty Committee, and I'm conscious our chair was an Amnesty Committee member.
Yes, you are correct.
So this was one of the challenges, I think, for the Amnesty Committee was that it had, and this was my experience dealing with amnesties through, as I raised earlier, through that pro bono work that I did with certain cases, was that the Amnesty Committee had a very limited investigative capacity, and while some investigators were allocated into the committee, this did not necessarily result in primary investigation around a number of the cases, and one had a distinct sense that the committees were often having to make decisions on the versions presented, which were hopefully robustly tested by evidence leaders, and often a reliance on counsel for families. But the discretion for cross-examination around notions of full disclosure and so forth varied from committee to committee. They were operating independently, of course. So, you know, the issue of full disclosure, for example, I know for many victims and survivors was extremely contentious in terms of what was put on the table because of the nature of many amnesty applications, in my experience, particularly from the security forces that were tightly developed, interlocked, and didn't give much away. They were, in many ways, contrived versions that were put on the table. And didn't look at the wider set of actors that were responsible. Can I give you two examples commissioners, the two examples of this. I worked extensively on the investigation into the murder and disappearance of Stanza Bopapi, for example, and that case resulted, as far as I'm aware, it's the only amnesty case which has from constable to the former head of the security police applying for amnesty. So you have this kind of chain of command that was there. But it's a limited chain of command in terms of the disclosures that were made. And there was a whole process of establishing a legend around a fake escape, because the public version of what happened to Bopapi was that he escaped from custody and ran away. And they created a whole legend around this with, and a docket with, sniffer dogs and God knows what that was in there. None of the people associated with those side investigations and those cover-ups were brought in front of the commission. It was just the line of people that were involved in his torture, his death, and the disposal of his body, and the authorization from the senior commanders. So that's one example. Another example is of a matter, for example, that was only heard in chambers, but related to a massive set of issues. This is 3 police officers who agreed that they doctored a docket relating to Temba Khoza, the former IFP warlord, who was found inside the Sebokeng hostel in September 1990 with a bootload of weapons from Vlakplaas. Yet that case never went and got explored beyond the fact that they just made an application for amnesty for doctoring the docket. That was it. So you didn't look at the wider angle implications. And I think this happened repeatedly in front of the Commission in terms of the sharing of information or the lack of sharing of information. So this was a concern. But again, I did not walk a mile in the shoes of the Amnesty Committee, who had to get through a caseload which was undoubtedly very daunting, and they had to push through these things with limited administrative and investigative support.
Can I ask Jonas, just a matter that occurs to me? The TRC process was in many ways quite extensive, but if one looks at the extent of atrocities committed during the period in question, 1960 to 1994, and the number of persons who would have been responsible for those atrocities, one must conclude in a sense that the number of people held accountable was very limited.
I think so. I mean, I think that's quite clear. It varies. I mean, I think one can calibrate
that to a certain extent. We know from amnesty applications that the bulk of security force applications came from members of the security police. I mean, this is an important set of cases that were covered, but they are by no means a comprehensive reflection of violations perpetrated by the security police or indeed other units inside the police. But there are other areas where there was very little interaction. The military effectively pushed back and did not engage. And there's a politics around that, which I think needs to be understood in terms of the forces that were in play that allowed the military leadership to effectively issue the opportunities for amnesty. And that still hasn't been examined properly. And I think that they played an obstructive role. It's instructive that the only amnesty cases from the military, the most important ones at least of the 17 or so that came, or was it 20 that came in front of the TRC, related to joint operations that they were involved in with the security police. So they were kind of forced to come forward in those instances.
Because the security police...
Because the security police were a central part of the operations that were killing activists inside the country. The Neerferdien 10, the Mamelodi 10 case, the Ribeiro killings and so forth.
Then, Mr. Figo, from paragraph 53 on page 2460, you deal with your further observations of the TRC. One of the issues that you raise is the case of Dupree v. the TRC in the then appellate division. You want to tell the commissioners why that case is important and what it showed about the entire process.
Thank you. Commissioners, this is raised simply to give an example of the kind of environment in which the Commission and more broadly South Africans were operating in. I mean, we're faced with an emerging and new constitutional dispensation in which the rights of individuals are given additional support. And here we have a case where the Commission was effectively forced by the courts to provide, I think it was the Section 30, I think there were Section 30 notices, they were called, that alleged perpetrators were to be given details of the allegations against them and who was making those allegations. This is an interesting, the way in which that ruling played out, in the opinion of a number of lay people, certainly from my perspective, did not lend to a victim-sensitive approach to these issues. I mean, if you made a comparison with the Mohammed judgment in the amnesty case, where there was a much greater reflection on how these issues reflected and were being navigated by victims who've been through deeply traumatic processes, were now expected to allow their names and details to be given to people who they believe were responsible for some heinous crimes. And of course the irony of this particular case was those that were the applicants in this matter and said that they needed this notification and had denied up to that point that they were involved in those cases. They were the very people that subsequently applied for amnesty for the killings in those cases. So there's that dynamic, and there's also the logistical nightmare that this created for the Truth Commission, with limited administrative capacity bandwidth to be able to go and locate relevant individuals to give them notices in time for people to be able to come in front of the human rights violation committees and make assertions about who they thought was responsible. I mean, it's a classic, it seems to me, a really important case for looking at rights and responsibilities, and whose rights were preeminent in that situation.
And if I understand your summary and what you set out in the reference that is set out paragraph 24, there was a difference of opinion between the High Court on the one hand and the appellate, the High Court and the appellate division on one hand and the full court on the other hand.
Yes, that's set out in here. In fact, you know, that there were different opinions, and of course, eventually, the appellate division ruled in favour of the applicants,
who were perpetrators.
Who were the perpetrators?
And we can say perpetrators, not alleged perpetrators.
No, they were the
because
perpetrators.
That's what happened.
They applied for amnesty subsequently, yes, for those particular incidents that were raised in the Human Rights Violation Committee.
And the full court would not have granted the interdict on the basis that victims too had rights and needed to be protected given the entire TRC process.
Well, that is the optics, certainly, I think, and I must stress this is from a layperson's point of view in terms of how I perceive that. So there was it seemed to me to be quite a narrow legalistic approach to something which perhaps a more activist mind may have had a sort of kind of wider angle set of concerns about the other groupings that were engaged in this in terms of the victims in particular. Yeah.
Now, from paragraph 59 onwards, you deal with a number of matters which you refer to as missed opportunities. before we get to that, you've written an article on which this part of your statement is based.
Yes, I wrote something in a book edited by Graham Simpson and Deborah Posel called Commissioning the Past. This is a chapter, well, I wrote a couple of chapters in that book, but this is a chapter which is reflecting on the work of the investigation unit of the TRC, and it's entitled False Promises, Wasted Opportunities. So that is, yes, it's the basis on which this detail is brought out.
And if I can ask you to look at page 2468, you'll see a reference to footnote 2. Is that the book and that's the article and the name of the book?
That is correct, and I have provided that to the evidence leaders. A copy of that.
Would you, though, go back to paragraph 59 and indicate to the commissioners what you regard as some of the missed opportunities in the TRC process?
Well, you'll see there's reflections on institutional relations between the Commission. And I'm focused here on the issue of the relationship with the Attorney General's office. And in particular, given the Johannesburg office, it was the relationship with the Transvaal Attorney General's office. Again, this is from the vantage point of someone sitting in a regional investigation unit. We did have 2 people seconded from that unit, yet we didn't have a constructive engagement with the Transvaal AG's office. One would have hoped, we know that during investigations into prosecutions, a lot of information is collected that will never be used for purposes of prosecution in terms of the evidence chain that you have to establish in a court of law. In fact, often the vast majority of a docket will not come in front of a court per se. But that information is still extremely important and can be utilized, particularly by those that have a wider angle mandate and also an opportunity to conduct inquiries on the basis of different versions of evidence or different forms of evidence. It perplexed me why we could not establish a relationship with the Attorney General's office that would allow the sharing of information that would enable the Truth Commission's own inquiries and the utilization of its different mechanisms, its in-camera powers of subpoena, and so forth. Because sometimes it really was a question of folk not knowing or having a sense that we may have more information than we had that led people to apply for amnesty, and I had some experience of that. But we seemed with the Attorney General's office to be engaged in some kind of territorial battle that was going on. So whilst I know there were attempts to have discussions with the AG's office, and there is certainly an example when it came to the chemical and biological warfare investigations around Dr. Wouter Besson, that there was some collaboration and some engagement there. By and large, there was not a sharing of information. There was a kind of institutional insulation from one another. And I think that was a huge lost opportunity for a much more productive interaction with the Attorney General's office and with its investigators. But I think that extends, though, into how did the TRC engage with other key institutional actors, the police, national intelligence, the military. And ultimately what happened was that we were forced to engage through what became known as nodal points. Now, nodal points, one can have a very cynical viewpoint. Nodal points are often established to ensure the control of information that gets out. And I think that the nodal point approach meant that we didn't have a proper structured access to police records. Certainly information was and requests were made to the police, and certain information came back. But there was not an effective, efficient system put in place. In terms of national intelligence, only those, and a handful of people got security clearance to look at national intelligence records, but completely insufficient in terms of the time made available, the resources in the Commission to look at a vast array of information that sat in national intelligence archives. And as I've indicated to you earlier, the military lied to the TRC in terms of its records and the availability of its records. And certainly did not come to the table to make those records available in the way that they should have. I think that to a certain extent the TRC, my sense is that they were abandoned to try and pursue those relationships with those institutions, but they were ill-equipped to do so and didn't have the kind of political support that perhaps was needed. But a caveat to that is that we have limited insights into the febrile dynamics of transformation processes that were in play inside all of those institutions at the time. And there was clearly elements within those institutions that had a direct interest in non-disclosure. Now, I'm not saying there is evidence of smoking gun to say that they stopped that, but the institutional cultures of the security and intelligence services do not lend to this kind of transparency. And I think that there was a meeting of minds between key elements within the new guard, meeting with the old guard, in terms of building relationships, building trust with those entities, which didn't lend to pushing for greater transparency and access for the Commission.
Can I ask you, in paragraph 60, you point out that the TRC, with all the challenges it faced, made a fair deal of progress, and you indicate how that came about. Do you reflect on that to the commissioners?
Well, you know, I generally, when I reflect on the Truth Commission, I have this kind of love-hate relationship with it. I'm deeply frustrated by what it could and should have done, I think, but also at the same time incredibly impressed by what it was able to achieve in a number of instances, operating in I think a challenging milieu. Let's not forget that in 1996, when the Commission was operating, we still had significant political instability particularly in KwaZulu-Natal. In fact, I think it has been established that whilst the Inkatha Freedom Party's president, Mangosuthu Buthelezi, came to the Commission, a decision was taken not to recall him for more robust, detailed questioning because there were concerns that this might have blowback around stability. So, you know, we were in an environment, I've talked about challenges of transformation within institutions that were taking place at the time. But I think in a wider political sense, this was a difficult time around the breakup of the government of national unity, etc., etc. So the Commission was surfing in a political milieu that was still pretty rocky in some respects. But importantly, this process had the protection of President Mandela and I think some senior cadres inside the ANC who were able to essentially force the whip on this within the ANC. Because even though the ANC voted en masse for this legislation, there were distinct concerns, I think, amongst the ranks of the ANC, whether in Parliament or elsewhere, about this process, which have subsequently come to the fore, in which the Commission is criticised for equating the violations of the liberation movements with the violations of the security forces, something that we can discuss if you want to. So I think that there wasn't support, really great support from those within the security forces, within the ranks of Nkonto Wisizwe or APLA, and certainly not from Inkatha. But I have one serious caveat to that in terms of those that came to the Commission and contributed. The ANC made more disclosures to the Truth Commission than any of the other conflict actors. through its submissions. And while we can be very critical about the limitations of ANC-related investigations, a lot more material was forthcoming from their side in terms of acknowledging responsibility, which I think, you know, was an important and a positive contribution to the overall Commission objectives.
That you deal with in paragraph 60, Ms. Speaker. All those matters that you've referred to now.
Yes, they're laid out there.
Yes. And then in paragraph 61, you make some observations about what the view of certain sectors of society were towards the ANC. Would you tell the commissioners what that was?
Well, obviously different perspectives from different conflict actors, but from those that were affected. Some people saw the TRC as politically biased, one way or the other, and in fact, as you will all know, three main conflict actors from the ANC, the National Party, and Inkatha tried to stop the publication of the report that was handed to Mandela in President Mandela in November 1998. So there was a lot of criticism from that side. I've talked about criticism from the activist community. I've talked about criticism from the survivor victim communities, which weren't particularly organized at that stage. There was the beginning of some organizational capacity there. But yes, I mean, I don't think anyone was running around saying that the Commission had achieved everything by any means whatsoever. I'd also like to point out, and I don't know whether the Commissioners are familiar with this, the vast majority of South Africans have never seen the Truth Commission's report or its findings and recommendations. There was never a popular report that was made publicly available to South Africans. So, you know, whilst it was in our homes every day in the radio and the television, particularly during those first 2 years of 1996 through to 1998, essentially there was not a wider discourse around this. And whilst we see some components of that in our education curriculum, by and large, there was a disconnect, I think, from a whole range of other transitional processes in South Africa at the time. It was kind of kept as a standalone. And I want to reflect on a statement that was made by, when he came here in the early 2000s, the French philosopher Jacques Derrida described our Truth Commission as an exercise in forgetting. Because once we had this statement-taking process and this public theatre, it was packed up and put away, not to be dealt with. And I think that is indicative of how the state and society more generally put it in a box and put it away. And that is the context in which the prosecution processes were not given wider attention.
Was part of the problem not the language barrier? The report was only in English?
I think that's part of it, but I think a popular report should have been translated into vernacular, and there was an opportunity to do this. We see that happening with a lot of other commissions around the world since our own TRC, but it was just astonishing that it was just, you know, once we'd had the debate in Parliament, and then this little subcommittee had been set up in the Department of Justice, it was packed away out of the public domain. Tick, done, move on. And I think that the disconnect, and I say this in this statement as well, the disconnect between the TRC and other transformation processes was by design, not by default.
Yes, thank you.
Mr. Speaker, can I then ask you, from paragraph 62, you deal with the issue of truth and reconciliation itself. I know this is somewhat esoteric and that's philosophical as well, but it is relevant for one's understanding of your views. Would you tell the commissioners about different aspects of truth that you deal with?
Well, I mean, this is predicated off the Commission's own internal deliberations and what it puts out in the public domain. You know, the basic premise of truth and reconciliation, the notion of reconciliation is, I think, mentioned twice in the legislation. But this notion that somehow the Truth Commission would deliver reconciliation is, and one of the sticks for which it is hit is that it didn't do that. Completely unrealistic to expect a commission to deliver that. But what Archbishop Tutu made very clear was that there could be no prospects of reconciliation without some foundation of truth. That truth did not necessarily deliver reconciliation, but you would get no reconciliation if these things were covered up. You know, even the forgive and forget notion requires you to know what you're forgiving at the end of the day. So that was a kind of premise around disclosure and ownership of violation. But the Commission allowed these different typologies of truth that went beyond factual and forensic truth, social truths, narrative truths, and so forth, which kind of was a wider angle on perspective, which I think fed into this focus on victim and survivors, and a more inclusive approach to these issues, because commissions of inquiry generally were obviously more focused on factual and forensic. And as I said earlier, this was a much wider angle on these issues. And the Commission was interested in perspectives, experience, these kinds of things as well. Not simply what could you establish in terms of a chain of evidence.
And to that extent, did it succeed?
I think that's a question that people will be interrogating long after I and others in this room have gone. I think what the Commission achieved was it established a critical foundation for further conversation and inquiry on a range of fronts, including investigation and prosecution. So that foundation was clearly established. I think, unfortunately, the environment in which we are operating in did not lend to that possibility being pursued on multiple fronts.
In the last two sentences of paragraph 65, you indicate what your view is of the necessity for at least finding out what the truth was.
Well, as I said previously, it really is. It's the precursor for possibilities for discussion and engagement that can lend towards a more reconciliatory. I mean, I personally was not a great supporter of this notion of reconciliation that was being pursued. I preferred the notion that an academic called Lee Payne developed called contested coexistence, that we can fundamentally disagree with each other about things, but we do that within the context of a set of rules in terms of how we engage, and that people should have, you know, the reconciliation processes for people are a process, and so there should not be an expectation on people. There are different pathways to the reconciliation market.
So long as, if I could just ask you for your comment on this, so long as we don't see reconciliation as an event, but rather as a continuing, unending process.
Sure, I mean, it can obviously be marked by events, but yes, absolutely. I mean, and it happens at multiple levels, individual, communities, and so forth. And I think this is another area where opportunity was lost post-TRC to drive momentum around those issues, which are tightly tied to issues of truth recovery, and I would say investigating and uncovering what happened in the past. And yes, that could include prosecution as well.
In paragraph 66, something that is more directly implicated in respect of this commission, you deal with why you, the two causes you say for the lack of prosecutions and the pursuit of truth following the Truth Commission process.
Well, I mean, the primary cause, and I think I've made that I've already testified to this, that it was the political environment and the institutional transformational considerations that were in play, the forces that were in play at the time around an accountability agenda. The extent to which that could or was destabilizing, and I think we don't know this because a number of the key actors have not testified. They were not in the room when this took place. I mean, I can't remember exactly where it is in the test. It's later, and we'll come to it in paragraph 73. But there was a real concern, I think, from those of us that were looking at these issues, that there was just no desire to get on top of these things and to provide the necessary support for those matters to move forward, whether it was archive, whether it was prosecution, et cetera, et cetera. So that for me was the primary concern, and the issues of the TRC had recommended in Chapter 9 of Volume 5 of the Commission's report. The recommendation said that there were no champions, really political champions, pushing these issues forward, and that civil society actors had not connected adequately those issues to contemporary challenges. It's almost as if this is seen as a historical exercise that is not relevant in the contemporary. And I think that this is a contextual problem in terms of, and it enabled those issues to be, using the kind of Derrida thing, become an exercise in forgetting, putting it in the box.
So,
if I may interpose, Mr. Soni and Mr. Pigo, how would the TRC have been able to identify champions in the civil society to propel its recommendations?
Well, you may recall the Reconciliation Rehabilitation Committee's, one of its primary responsibilities was to have an interactive process with a range of constituencies in South Africa to explore recommendations. And I think that again, by design, in the process of those interactions with a range of different actors, the issue of how the mechanics and what was realistic to drive those things forward should have been very much in its thinking, as opposed to just a wish list that was put out there, some practical recommendations about which institutions could have taken certain things forward. I mean, there's some reference to like the Human Rights Commission and those kinds of things in there, but I think if we had a keener appreciation of other transformation processes that were taking place, and particularly around institutional transformation in the security and intelligence services, for example, there could have been an opportunity for an identification of people that might drive those issues within the state and within civil society. So for me, that's what this was about, that the TRC had an opportunity, and this is, of course, with the benefit of hindsight that I can say this, but I think any process that is promoting recommendations should have some kind of interactive, if that possibility is there, some kind of inclusive and interactive process with constituencies who may be able to make pragmatic recommendations on driving those things forward.
Thank you, Mr. Soni.
Thank you, Chairperson. Mr. Pigo, in paragraph 67, you deal with an issue that has emerged during the evidence, especially more recently, about how did it come about that it is the NDPP that was driving the investigation and prosecution process, as opposed to the South African police, who would ordinarily be the first port of call in regard to the investigations of crime.
Commissioners, I'm not in a position to advise what was said. I can speculate about why, and one speculation really is that the NPA or the NDPP was seen as a safer pair of hands than the South African police. And I would concur with that if one looks at what the police, well, the state of the police then, that this wasn't necessarily going to be a safe pair of hands. So that would be my speculation.
Then you deal with, from paragraph 68 onwards, the missed opportunity in relation to the Jack Cronje revelations.
This is just an example, I think, and bear in mind I'm again talking about the Johannesburg unit. It's not as if there weren't efforts by elements of the Commission to look into the versions of Cronje, the Cronje 5 as they were known, the Northern Transvaal security police officers that had been under investigation by the Transvaal AG's office, and then effectively that prosecution was stopped when they all applied for amnesty. For me, it's a good example of, there's a lot of information that came out of their amnesty applications that would have been very useful for the pursuit of wider angle human rights violation committee investigations, but this simply did not happen. There are examples of where it did happen, but there are many examples of where cases such as those of that unit and the institutional relationships between different parts of the security establishment, what I would call the kind of infrastructure of repression, were not laid out clearly. And you can see this in the TRC's report as well when it tries to explain structure. It struggles with understanding structure. And colleagues of mine who work in this space today and I still have an interest, we still struggle to understand structure and responsibilities within the security environment. So, you know, a lot of this information was not systematically gathered in a way I think that it should have. And then I've mentioned the ANC cases. I mean, let's be clear that there were no real detailed inquiries and investigations into the ANC. ANC cadres, MK cadres, came to the TRC in large numbers to the Amnesty Committee. In fact, more Liberation Movement members came to the Amnesty Committee than former members of the security police or the security forces, which tells you something as well in terms of engagement. But the TRC itself didn't dig down, for example, into issues around the atrocities in their camps. It was presented with a lot of very useful information by the ANC about those things, but it didn't go on independent inquiries. And one of the criticisms of the Truth Commission regarding the ANC was, well, it only went after Mrs. Mandela with the Mandela case. And that impression is very firm in a number of people's minds. So, you know, we can see that a lot of things were not pursued, including also high-profile cases. And I refer, for example, to two matters that were crossed my desk while I was in the unit, which were, you know, the death of Neil Agate and the death of Ahmed Timol, which were not robustly followed up. But, you know, it was one of maybe 100 cases sitting on my desk. How much could you really do in a period of a few months with all these other responsibilities? So I think that reality needs to be very clear, that it was a number of high-profile matters that didn't get attention as well.
We're dealing still with the question of why the prosecution process has been so slow since the TRC process was finalized. One of the issues you deal with in paragraph 73 and 74 is the issue of a possible or an alleged non-prosecution deal. And you deal with your interaction with Mr. Jan Wagner on this issue.
Yes, I mean, I knew Jan Wagner from the TRC representing a number of members of the security forces, particularly the police, but we happened to be, and I've been unable to get lock down the detail of the dates when it was, but we were in Boston at a conference that was hosted by Mr. Porrig O'Malley, who some of you may be familiar with. He's the biographer of Mac Maharaj and did a lot of work here in the late 90s and early 2000s on recording events related to conflicts of the past. And Porrig had invited us to this conference in Boston, and Jan Wagner was there, and we had several conversations.
What year was that?
It's either late 90s or early 2000s. I've been trying to reach Porrick to get a record, and I'm still trying to lock down the date there. And I spoke to Wagner on a couple of occasions. Once in his hotel room, actually, one of those conversations in which he talked about a deal that was effectively on the table, that there would not be any prosecutions against security force members, and if there were, then there would be a backlash. And that backlash, he didn't exclude criminal prosecution, but the thing I remember distinctly was him talking about how they would asphyxiate the ANC in civil courts and take all their money, you know, for these cases relating to past conflict. And we had lengthy conversations about two lengthy conversations about that issue, that there was a deal, an unwritten deal.
And at paragraph 74, you indicate which side you think the facts point to.
Well, I mean, my sense at the time is with the asphyxiation of resources and we were at the time, I remember being very angry with the NPA in particular. I saw them as the primary obstacle. I mean, I heard the stories about the police were not being cooperative and there was no allocation of resources and so forth, but yeah, I mean, I saw the prosecution services as the prime. One of the things this commission has provided, I think, is a wider insight into other factors that were in play there, and I'm still struggling to understand how police officers can refuse to be deployed, and in terms of a chain of command. I mean, it's astonishing to be deployed. So, you know, in many ways, it's opened more questions to me about the infrastructure that was in play around decision making. And where those blockages came. But ultimately, it seems to me that there was an absence of political will to make sure that those issues were properly addressed. That the political principals in these offices should have been getting clarity from their administrative principles on why certain issues were not being pursued. I mean, this is obviously part of, or central tenet of this commission's work. But the impression was very, very clear that there was a deliberate asphyxiation of resources and a lack of political will to pursue these matters. I think one case, actually I mention it later, is the one that just perplexed me, was why Eugene de Kock's commanders were not under the microscope and not being pursued. I mean, I met with him in CMAX in the late 1990s, and he was banging the drum then about why me only? Yeah, what about the infrastructure that was all around me? Of course, you know, the me only story fed into the rotten apple argument that certain people put in front of the TRC, which was the National Party position of F.W. Clerk and his colleagues. But it just made no sense to me that there was not an evidentiary basis to pursue the senior commanders inside the security police that were fully aware, instructed, rewarded, and so forth, Eugene de Kock. And I would still say that I still don't understand why those cases were not pursued. And I can only surmise that it was not a priority. There were limited resources, and it seems to me that there was a decision to not act. This was an act of omission, which we've seen on multiple fronts.
Then, Mr. Pigo, at paragraph 75 and 76, you deal with other possible explanations why there hasn't been any real traction in regard to investigations and prosecutions of such cases.
Yes, and this is just to briefly reiterate what I said earlier, is that I think that the political conditions and the institutional transformation constraints and the absence of, I guess, political protection around that agenda, which we saw for the Truth Commission, as I said, from President Mandela and a few senior cadres to allow that process to continue relatively unhindered. That combination of factors lent to a set of political decisions not to pursue these matters. This is my sense. I mean, I'm desperate for the key political actors to explain themselves. And that's what we're obviously hoping for, is that the political principles will be more candid with the South African population about what were the constraints at this time, what were the pressures that you were under at this time, who were the actors and in which direction were they pulling. And as I said earlier, this also doesn't relate just to the TRC. This is part of a wider trajectory of how political actors have navigated those issues, from the apartheid era through to the negotiation period, through to the post-94 period. And I don't think we've had a candid conversation about those issues.
In paragraph 76, you highlight the case of Philip Powell being allowed to leave the country, notwithstanding non-disclosure of a massive batch of arms somewhere
this for me is indicative of the political deal-making that was going on around the MPA. Powell, who then was an IFP senator, had a background that had come from the security police, and then he was the guy that ran Inkatha's self-protection units and was the recipient of tons of arms from Vlakplaas that de Kock had brought down from Oshikati in the 90s and 80s. Powell was treated with kid gloves, effectively, and was given a deal if he would point out
from
where the
Oshikati in Namibia.
Southwest, yes. So that was in the late 80s when weapons were brought down and stockpiled in different areas. But many of and were in the custody of Vlakplaas. Many of those weapons then subsequently were handed over during the 90s to the self-protection units. I mean, the police were engaging with Inkatha. Obviously, there was a background relationship between the military and Inkatha around the Caprivi trainees and so forth. But that relationship put Mr. Powell in the crosshairs of culpability for what was going on. As far as I'm aware, Philip Powell never applied for amnesty. Presumably he'll say he wasn't involved in any gross violation of human rights, just an accessory, perhaps. But he was allowed to leave the country in a deal that we don't know the detail of, in exchange for disclosing the whereabouts of those arms caches. And it is a widespread allegation that tons and tons of those weapons were not disclosed in terms of their whereabouts, and in fact that he violated that agreement. But there was a political deal, it seems to me, to allow an IFP senator who had the protection of potentially destabilizing Inkatha Freedom Party, but an Inkatha Freedom Party that the African National Congress wanted to make a relationship with in the late 1990s, and did so. Again, I'm urging us to understand the politics the political dynamics that may have been in place, and we need to try and understand that. It may well have been an appropriate approach for some people, but we need to understand the logic of what went there, and I fear that those kinds of decisions have been locked away in a box for us never to look at. And maybe that's appropriate, I don't know. But from my perspective, of someone trying to understand the past, it's a problem. It's a challenge for us.
Mr. Pigo, then from paragraph 77 to 81, you set out what you want to say in conclusion of the evidence you've given. Much of it is you've already referred to, and I ask you to briefly summarize that as the last part of your evidence.
Very quickly.
Maybe just read it out.
As you
okay.
please.
Thank you, Commissioner. Paragraph 77. in conclusion through to 81. In my view, there was no political interest or will in investigating and prosecuting crimes of the past. I think there are several factors that point to this. If you take the TRC recommendations and distill them down to a smaller group of issues through a parliamentary ad hoc committee, and then establish some kind of tiny under-resourced subunit inside the Department of Justice, what message does this send? These institutional responses were a clear indicator of a lack of political interest, and subsequent experiences reflected the lack of administrative bandwidth and limited traction on many TRC-related issues, many of which are still in play. The acts of omission by state actors at the political level and senior administrative level constitute reinforcement of this, whether it is the lack of resourcing of investigations, whether it is how they dealt with memorialization or archives and records, and how they have dealt with the reparation agenda. Bear in mind, though, that this was enabled by the process and design faults in the TRC itself. I think that it was not an oversight that the TRC was set up to be deliberately isolated from other transitional and transformational processes in the country. Whilst it was one of the failures of the TRC to not hook into these other transformation processes that would allow the momentum of what it added to the debate to be carried forward on these issues, there is a substantial chapter of recommendations which the state did not take seriously. Unfortunately, there was no one pushing for this. There were no champions to hold them to account on these issues. No one in that context within the ANC was ever going to champion post-TRC stuff, although certain individuals tried to advance that process within a context of competing priorities. Paragraph 80, one of the issues, and I've mentioned this now, that intrigued me was why perpetrators like Eugene de Kock's commanders, such as Krapis Engelbrecht and Barcy Smit, were not prosecuted as priority cases. De Kock and others have evidence to underwrite the solid investigations which could have been done with the proper resources. However, having regard to the context, I am of the respectful view that there was slow peddling from within the NPA, which itself lacked resources to push beyond the caseload. Ultimately, in the context of institutional and policy dynamics, a politics of prosecution reflected an absence of political will to pursue these matters. This was particularly indicative of the Mbeki administration. This applied not only in respect to prosecutions but also reparations, in which I also had quite serious disputes with the Director General in the presidency, that was Mr. Frank Chikane at the time. Be that as it may, I'm of the view that much that was left undone or unfinished was as much a result of omissions as well. I have mentioned Mr. Mbeki several times. I believe he has a duty to account to South Africans for this state of affairs.
Ms. Pigo, in conclusion, you note that there is an obligation on Mr. Mbeki to address the nation, as it were, on this issue. But I heard you earlier say that there are many other people who should do the same.
I think what we failed to do is have a conversation after the Truth Commission about these issues. And I think obviously the primary political actors have also failed to... I mean, it is fascinating to me that this prosecution issue has... that political parties, for example, across the spectrum have been largely silent about this issue. There's a little opportunism that we see every now and then from certain actors, but by and large this is just off the radar for so many people at that level, at a political level. So yes, at that level, but also I would say wider than that in terms of other constituencies, and I would include ourselves in civil society for that a lot of great work's been done, but perhaps we could always be more strategic about how we did it.
Chairperson, that is the evidence that we wish to lead.
Ms. Moroka?
Thank you, Chair. We intend cross-examining the witness. I will not be able to give you time frames because a major challenge that we are going to face is that a huge portion of what he has had to say relates to the TRC. He calls upon Mr. Mbeki to come to this commission to come and give evidence. We have issues about the TRC process itself. We would need to take a very long and hard view as to what we do with this witness and his evidence. So we are going to consult extensively. I'm unable to give you a date about cross-examining this witness. Thank you, Chair.
Yes, so your attitude now is that you are going to consult your clients and then come back with a view of whether you want to cross-examine him or not.
Cross-examine,
You are definitely going to
cross-examine. It's the how and the content thereof that constitutes a challenge. Thank you.
And the when you wish
That's the
to
problem.
bring an application for cross-examination?
But therein lies our problem, Chair. That is why I started there.
Yes. Yes.
Thank you.
Ms. Mtloko?
Thank you, Chair. We also have a similar problem, but I can inform you that we will apply for cross-examination of this particular witness, considering the averments that he has made in relation to the National Prosecuting Authority.
Yes.
But we do need to consult, and we will need to consult as far back as the first NDPP based on what he's now said. And also, Chair, just to put it on record, it may well be that we may also be applying for other considerations, including certain parts of his evidence to be removed because they might fall outside of the mandate of this commission, based on, for all intents and purposes, for almost an hour, we heard about the TRC and the commission's terms of reference state from a particular time until a particular
Yes,
time.
I'm more interested in whether you are going to cross-examine the witness or not.
We will definitely be cross-examining
Yes.
the witness.
When do you intend to bring your cross-examination?
Chair,
Your
that's the
application?
difficulty, because we have to fully canvass the matters that he has now dealt with various people that may well be, well, some are no longer at the NPA because we're talking about 1998, 1997, and the likes. And therefore, we will endeavor to bring it as soon as we possibly can, but I don't think we can put a timeline to it at this point.
Yes. I think you are aware that we are a time-bound commission. So that's why it's important for me to elicit the time within which we wish to bring an application for cross-examination.
Yes, Chair, we really do appreciate that. Unfortunately, while we will do everything in our best endeavors to ensure that we bring the application as soon as possible,
Yes.
we need to ensure that we are able to meet with the relevant persons who would have been there to answer some of the questions that we ourselves will then have as the National Prosecuting Authority.
Yes.
Because as you would have heard, Chair, some of the things the witness himself said, I speculate that this would have been the reason. So we would need to understand, is that in fact the reason? So the best I can do, Chair, is to say we will try, understanding that this commission does in fact have a timeline, like most commissions. We will try and give an indication of where we are by the end of the week next week.
Thank you.
To let you know.
I
by
think
when.
that would suffice.
And if I may, Chair, point out that given the evidence of this witness, we have also suggested some names to the evidence leaders in an effort to, excuse me, to make sure that we wrap this up. They do know that we've suggested names. Therefore, we really find ourselves in a difficult position about giving you dates.
Yes. But Ms. Moroka, may I also implore you that you give me an indication by end of next week on Thursday.
Chair must remember next week is very short. We will
Yes.
try.
Yes, please do try. Anyone online?
Thank you, Chair. Ms. Ntambeleni, no questions for this witness.
Thanks, Ms. Ntabeleng. Anyone else? Mr. Vani? I think there's someone online. Anyone online? No. Thanks, Mr. Vani.
Chairperson, we have no questions.
Thank you. Mr. Pigo? Oh, Mr. Soni?
We are in your hands, obviously.
Yes. Mr. Pigo, we thank you for having been available to come and give evidence before this commission. As you have heard, there is an intention to bring an application for your cross-examination, and you will then be expected to come back to this commission for the conduct of such cross-examination. But for now, you are excused as a witness.
Thank you, Chair.
These proceedings are adjourned until tomorrow at 10 o'clock.